I'm going to call this meeting to order of the election board. We are going to come back from recess. Actually, I believe we recessed last time. We don't have any minutes to review or anything like that. We just have two items on the agenda. We were going to be here either today or early next week to review the draft letters that we spoke about at our previous meeting to go out to a few folks. But since then, I had County Council, EL, not IL, SEL, not CIL, sent a couple few memos, and I was scratching my head the whole time because initially, and Mr. Loffman, this is even prior to you, we had voted on X amount of codes that we were going to cite in this to provide to Mr. Bender. And I just kept reading in these memos that we can't send for prosecution for a particular one, and I had no idea why. So I took the just glorious endeavor of reading law, which was fun. I read a ton of code the last few days, and I have consulted with IED as well. So the first item that we had on the agenda was to whether erroneous.
Consulted with
IED, Indiana Election Division.
Got it, thank you.
And that was just in terms of general questions about how the code reads, why it reads the way it does, so on and so forth. And in those conversations, a couple things came to light. Number one, we don't even really need to cite any of these codes in order to have a hearing. We need to cite that we believe an election violation occurred. That is what we need to do.
We don't need to cite them to Mr. Bender, or we?
Correct, at all. Now, that doesn't mean that we're not going to. I think that's probably more than acceptable and okay, but what we did do is during that process, we cited 4 different codes, and 3 of them were not actually under 3-14, which is the violation section of election law. And so whether erroneously, whether in just the rush of everything, it's kind of irrelevant what we did, but we have an opportunity to correct that. We basically identified 4 things, and they had to do with voter registration and candidacy registration / paperwork. And so in reviewing the law, under 314, there are 2 things basically that talk or speak directly to those, and I provided both board members individually what those were, just in PDFs. So I think that, and perhaps we should read them into the record, I have no problem doing that, but 314-1-1, which is the one thing that we actually did identify that was under 314, in my research and in consultation with IED, that actually speaks solely to a presidential primary candidate. So that's not really something that, although the wording and the language makes total sense for what we were trying to get at, since we are identifying specific code, I think it would be right to correct this at this time prior to sending out any letters to Mr. Bender or anyone else. Again, we don't have to do that, but it's something that I would feel comfortable correcting. So the 2, just so we're all aware of what they are, or the 4 that we cited originally were 3552, 38127, 31411, and 3811. And again, all 4 of those had to do with candidacy or voter reg. So in my research, I found 2 that under 314 that really fell under those 2 categories that make perfect sense for what we were trying to get at from the beginning. And that was 314-113, which is titled Filing Fraudulent Reports, and I'll just read it very quickly. It's 1 sentence. A person who knowingly files a report required by IC 39 that is fraudulent commits a level 6 felony, and that 39 has to do with campaign reports, campaign filings, campaign reports, so on and so forth. So that's the first one. And the second is 314-3-1.1, which directly speaks to the voter registration. That's titled Procuring or Submission of False, Fictitious, or Fraudulent Registration Application, Procuring, Casting, or Tabulating False, Fictitious, or Fraudulent Ballot. Person who knowingly does any of the following commits a level 6 felony. 1, procures or submits a voter registration application known by the person to be materially false, fictitious, or fraudulent. 2, procures, casts, or tabulates a ballot known by the person to be materially false, fictitious, or fraudulent. So obviously, number 2 has not been committed anyway, because no votes have been cast as of yet. Regardless of what the outcome of this is, that would be an impossibility. That said, I'll get to kind of that note here in a second, but so it would be my wish that after review and any questions we might have, that we would actually strike the 4 that we noted before and just replace them with these 2, which get to exactly what we were initially talking about, which was the voter reg and the candidacy files. One couldn't happen without the other regardless.
May I ask a clarifying question? Are you saying there is a part of statute that is only ever applicable in a presidential election that has to do with fraud?
Yeah, so 3-14-1-1, and I'm not an attorney, so please chime in if you wish to. But the way I read it, I may not be an attorney, but I certainly can read. And as we know, these other laws that we cited, these other sections of election law, those are the codes that are violated to lead to 3-14, right? That's the wording. So 3-14-1-1, which we cited previously, speaks to 383. And that specific language is a section that talks about candidates that are filing as a president in the primary, or filing for the presidential primary. So it's a little bit obscure and different. I don't mind leaving it in there, I just don't think it makes sense, and I think we have an opportunity to correct it. That's all. Again, it doesn't say anything in 311. Back in 383, it speaks directly to that. So the other 2 are exactly what we were talking about. They speak specifically to candidate and or voter reg.
Well, thank you for your diligent work. It's something I haven't looked at, and unfortunately, I didn't know that you'd sent. I sort of shut down getting ready for this, and had to do some other things. So I haven't. I've only now looked at these statutes. The 314.
That's not it, what you have pulled up.
2-9.
Does it help just to
Yeah, these are the 2 that
Yeah,
we're talking
okay.
about.
Okay.
So you have them on paper.
Well, thank you. Right, person who procures or submits a voter registration application. And Nicole, the other day, you showed me his application. You
Yes,
had
we
that
were,
with you.
prior to your coming on board as a proxy, we
Yeah.
were given a copy of the paperwork where he changed his voter registration to the East 16th
Yeah.
address.
Right.
And what was pointed out at that time was that predicated, him doing that, initiated that ball rolling for
And-
what he went on to do as far as
Right.
the candidacy paperwork.
And my narrow, sort of silly question, but on the other hand, if it, was that a voter registration application? That document, I think, was a
Yes.
voter
I have
registration app. And I didn't get copies of those things, unfortunately, and wasn't able to procure it from the time I started trying this morning.
We have it somewhere for sure for your review.
Yeah, I know, Nicole, and I don't know what the practice is, in this entity. Do we first name each other, or Mr. and Ms. each other, or is it variable?
My name is Nicole. Okay.
I only make people I don't like call me by my titles.
Okay,
Donovan's fine.
I have a copy of his voter registration application that was completed on January 20th, or he dated it January 20th of 2023. I'm happy to step away and see if I can get a copy for you.
Well, let me hold it for just a minute, and then I would like probably to do that, but we may have a bunch of stuff we're gonna want to get copied it all at once. But this is, okay, this, to me, this, what I like to see is do they line up exactly? And this is a person who submits a voter registration application. This is a voter registration
Yes.
application.
Submitted this
Which
year.
gives an address which we suspect is not, is false. And it's curious that he has a different mailing address that he lists here, which sort of implies he may not actually live there, since that's an apartment address. Okay, having just looked at this stuff, it appears pretty darn straightforward, as statutes go, that this is a directly pertinent and important statute. And if we want to cite statutes, we should certainly cite that one.
Agreed.
Okay. Now, let me look at the other one that you've just given me a copy of, which is the 1.1.
Here's all the candidacy filings as well that we were provided. I don't think I have a copy of that voter reg anymore. I think I.
Okay, that's
left it on the table.
1.1. Okay, files a report that is required by IC 39.
IC 39 is the candidate filing. I don't know if we have the power to pull it up. I could pull it up on my phone, but that is all of this that has that address on it, which is why I kind of tuned into that one.
Can I hold that for, I'm sorry, and as you know, I haven't been here from the start, so, what I'm struggling with is this, the first one we looked at was so deliciously straightforward. It said voter application, registration application, and they lined up exactly.
There's a lot more for candidates, that's why. I'm gonna pull it up for you right now.
And these are 3.8, not 3.9. And somehow, looking back in my 15, 20-year-old memory, if we can pull up 3.9, and I can probably get it.
So, the one that you're looking at with the statement of organization, where he named his committee, that statute is right at the bottom of the page,
Is it?
underneath his signature, where it says, anybody who knowingly files a fraudulent report commits a level 6D felony, and it cites the statute, and a person who fails to complete an accurate report commits a Class B misdemeanor, and it cites the statute. So that's right at the bottom.
Got it.
So that makes
Thank
it
you.
easier.
I got you.
better
I
than
never
Google.
went to law school, sir.
It's better
Well,
than Google.
if I'm, yeah. Okay, I've now gotten myself comfortable with the research you've done being accurate and to the point. And I would note, what we were looking at was a misdemeanor. These are felony
Correct.
documents that you,
I believe it
concerns.
was.
And I think we don't, it would be unfortunate if we cited something which was a misdemeanor, and then it turned out he was charged with a felony. I think if there's a risk of being charged with a felony, and we're going to say anything about it, then these are the better two statutes to use. And I'm comfortable with the substitution you've suggested.
Okay.
Council, are you tracking what we're talking about here? I bet you are.
I have the 4 that were cited, and you read it off earlier. The conversation is to change those 4 to 314.113 and 314.3-1.1.
Yes,
Okay, I'm following.
got it.
So, in my mind, I feel
I'm
as
gonna walk off
though
this, but-
it would be better to offer him, to make sure he's aware of every possible option, felony or misdemeanor, because one of the things we talked about initially was something could come out as we are looking into this, and we need to be open to other things coming up. Or the reverse could happen, which would be, I'm sure, more hopeful that we've looked into it, nothing to see here, and then it is taken off. But if he has more information than less information, he can never say he wasn't made aware of all of the options on the table as far as what we're looking at.
Well, I hear you, and I think it's a perfectly appropriate concern. My knee jerk is, we're not lawyers.
We are not,
We're
I
doing-
definitely am not.
I once upon a time was a lawyer, but that's been years ago. And our duty is to give him notice. The prosecutor, when the prosecutor investigates, who is a specialist in the criminal law, isn't limited by what we tell the prosecutor we want investigated. The prosecutor will carry on an investigation and use the prosecutor's resources. And I don't want to undertake saying that we have an exhaustive list. If it's not this, it doesn't count. I don't think we can go there. And like the one we found that if that just deals with presidential candidates, you know, I don't want to put in things that I think may be inappropriate.
And I don't want to either.
Yeah, these are, okay.
I don't want to either. I think the discussion that we're having right now is indicative of, this is what we learned. We're learning about this just like everybody else.
Yes.
This is what we found. Someone with a higher degree than I may say, this is, you know, you're interpreting like, it doesn't make sense to me that there's a presidential one. You can commit more
Right.
fraud in a presidential than you can any other kind of election, but that's what you found. Okay, we can take it off the table, but we legitimately found some things that look applicable to what we're looking into. And it makes sense to me that more notice than less of, hey, here's what we're looking at. Because again, we keep circling back to my concern that if there was not something more, this would already have been explained. And it has not, no one has come forward to explain.
Well, I'm comfortable with these two. Do you have any others you think we should consider?
These two being the felonies.
These two level 6 felonies.
I'm fine.
Okay.
Let-
Anything else that we think we want to put in the laundry list here?
Let me add one thing. The only other, I quite literally read every single sentence and letter of 314. And the only other one that I found that was applicable at this time, for where we're at now, was 314.22, and that has to do with fraudulent application for registration or procurement of registration. I thought it was a bit more ambiguous, and I thought that it's a, as I read it, I thought it was leading more to if you file a registration and vote. So there was a bit of an if-and on that one, and I thought that, why? Because we already have a voter registration one that's very direct.
It's very direct.
So that's the only other one I found. That doesn't mean I'm right, that's just what I found in my research.
I do have one more,
Okay,
because I don't know what but I don't know what the level is. He signed saying the information I have provided is true, under penalty of perjury. Do we have one that just says perjury?
Yeah, so there's no code under there's nothing that speaks to that directly. But I think that is exactly what Mr. Loftman and what you were speaking to, that the prosecutor, should it be referred, can do whatever they will with the information that we have. And I think the perjury charge, that is, the way I read it, we cannot really investigate that, for lack of better terms. I think that's for the next stage, should it ever get there.
That's not election law. That's,
Correct.
that is
Criminal law.
General criminal law would be perjury, and I think you're correct.
Is that fair?
That is a potential violation clearly stated apparent in these papers.
Because it says, if I have provided false information, and I get that we're not completely there yet, and there could be a plausible, I'm still holding out for a plausible explanation. But if I have provided false information, I may be fined, imprisoned, or if you're not a U.S. citizen, deported or refused entry to the United States. I don't believe anybody's questioning his citizenship.
As a consolation prize, would you be accepting of, should we move to that direction of referring to prosecution, that we make sure that we note, please take note of, Mr. and Mrs. Prosecutor, please take note of these documents, and that it speaks directly to perjury?
I would be fine.
Is that fair? Okay, so on that item, do we have a motion?
I'm sorry, I was looking at the statute on perjury, and which is,
It's
which
not
is
an election.
3544.1.2.1, isn't an election law. So I think we are not tying the prosecutor's hands by looking at the election law violations.
Okay.
And I don't know that there's any reason for us to point that out, because it's not our job. That's their job. So now, are you suggesting we have a motion to substitute those two citations? Let me get back to that screen.
In lieu of the 4 that we have.
Okay, here we go. Okay, I think this is what we're all talking about. I am looking at the notice of a hearing.
No, we're not there yet. We're just talking about the
Okay.
site. We'll get to that
Okay.
specific part. That's just the draft.
I move we delete our, looking at Indiana Code 3-5-5-2, Indiana Code -3-8-127, Indiana Code 3-8-1-1, and Indiana Code 3-14-1-1, that we delete those as items we are concerned with, and then we substitute for them Indiana Code 3-14-1-13, candidacy reports, and 3-14-3-1.1, voter registration.
I will second.
Someone call the roll, please?
Oh, you want me to,
Sure.
or you guys could do a voice vote since we're all in here.
All in favor, please say aye.
Aye.
And against? Motion passes.
Is that 3-0?
I'm sorry.
Did you vote? I did hear
Aye,
you.
yes, sorry.
Okay. No, that,
I was quiet. Okay, so thank you for that. Now, I would like to, it's not necessarily, it's kind of a part B of that first agenda item. In my research, I found more than a few things that I think it is our duty as a board at this point, or certainly my duty since I'm the one that found them, to make everyone, including the potential subject of this whole hearing, aware of the potential for a plethora of additional charges by the election board, should the election board feel that we need to refer this to prosecution, I want to make note that our hearing is post-primary election, and if we find that X, Y, and Z are true and we want to move to prosecution, that there are 4.5 additional things that will have been committed should Mr. Bender vote in the primary. We don't need to go through them. I just want to make, again, I felt it was in good graces, our duty to make the public aware of that, that all of this is quite tied together. I'm happy to cite the codes if anybody wishes that I found. I don't know that it's necessary, but what I would say is if we feel that these things are true, right, and we feel that we've already moved to have a hearing that has been scheduled, should we find that Mr. Bender voted in the primary, it is my opinion that we have no choice but to add these additional 4 charges.
Because if he votes, he's voting saying that the address he's given
Correct.
is accurate.
Correct.
Yeah, from my perspective, registering is illegal, voting is illegal.
If
and that's-
the registration is
if the
incorrect.
Yes, and it's illegal to file an improper voter registration, and it's improper to vote if you have an improper registration. That would be a crime he hasn't committed, and we hope he doesn't.
Correct. And so I again, in my research, I feel that it's very important to make that note because I certainly am not, that's not a veiled threat. That's not, that is just if we are already there to a hearing that is post-primary and we find that Mr. Bender votes based on this voter registration, we will be forced, at least in my eyes, doing our due diligence to add these additional things to forward to the prosecutor, should we find that he's guilty of all this.
Okay, so let's play this out, and I'll use me as an example. Early voting starts next Tuesday. Please check your voter registrations and make sure everything is in order, so that you can show up beginning Tuesday morning to vote. I tend, perk of the job, to be the first person to vote in Monroe County because I want to be aware if there's an issue throughout the process. I want to be aware first, and we get our IT people and everything. So it tends to be that I hand them my driver's license, and they pull up my voting information, and they ask me to confirm that that is my name, that is my address, that is my precinct, so that they know what ballot to issue to me. And then you proceed on to the printer, and then you proceed on to vote, and then you proceed on to put your ballot in the envelope and hand it to them and get your I voted sticker. With the information that we have now, with the East 16th address, if he showed up and presented his license and confirmed, I mean, there's a lot of things that would have to happen. He would have to confirm that that was his address and say, yes, that's the correct precinct, and get the ballot and go vote it and turn it in, and then get the ballot has been cast. And so if all of those things happened based on this address, then the board would have additional considerations. We would have no choice
I don't feel we would have a choice.
but to have, because people are going to ask.
My feeling is, well, I could use a slightly different verb. It's the bottom line is saying we would have a duty to investigate.
Fair.
I don't know what we would do following the investigation because I haven't investigated yet, and I'm not going to commit myself to an outcome. But if he votes, I agree, we want everybody in the world who's listening to know that might well be an additional set of crimes.
Correct. And thank you
And
guys.
you have done some research on what those would be?
Correct. And again, if you want me to read them, just the titles, I'm happy to. I don't really feel like reading all the paragraphs, but I don't know that we're even there yet.
I don't think that we're there
I don't think we're
yet.
there.
Good.
We don't have to, I don't feel we need to go any farther about letting the
Wonderful.
world, we know, don't commit any more crimes.
That's where I was at.
Yeah.
Look, we're giving you the opportunity, anyone out there, to let you know that if you've falsified a voter registration and vote that ballot, there are a slew of additional crimes that have been committed.
Well,
Fair?
and I don't even think we need to go that far as saying if you have, someone may not have updated someone may have moved in the last 30 days and not updated an address.
I
So
think
let's,
fraudulent is a
Correct.
very good
Right.
word to make sure we keep in mind with this discussion.
so I think the fairest thing to say to the voting community is there is still time up through Monday to check on your voter registration, ensure that it is valid, make the appropriate change if it is not, so that you can vote in the election. Because we want everyone who is eligible to vote in the election to be able to do so. Having said that, as you said, if for some reason it comes to light that anyone, we're not singling out any person, but anyone votes knowingly from a record that is no longer valid, that we might have to look at other options available to us.
Agreed.
Should a complaint be
I agree.
brought to the board.
I agree.
Okay.
Okay.
I just wanted to make note of that. I felt that was important for everyone to hear. So, having said that, we can move on to the next item, which is the review of the draft letters that we had requested. We have two of them. I went ahead and just made my own red lines for review that we now know at least the citations are now correct, so I'm going to just go ahead and circle those on there. But we'll go ahead and request that be changed, but I guess we could or should just start at the top. And let's start with Mr. Bender's, if that's okay. So a few things that needed filled in. The address was one of them. I think that it is my opinion that we should put both the mailing address and the registration address and mail a third copy to his counsel that we have clearly been made aware of. Is that fair?
That is fair.
That's what I had noted on mine.
And that makes sense, because if you send it to the E16th and it says, person doesn't receive mail at this address,
That would be additional
that
evidence,
solidifies
some way, sort of.
concerns or clears up some,
It's additional
it's
evidence.
additional.
Then I don't know if we want to go line by line, I'm happy to, but I am a big proponent of conciseness, and so there were things that I thought that we just didn't need to have in there. And that was based on the different memos and consultation with IED and so on and so forth. So the very first one is the third line down, as a Democrat running. I think that's irrelevant. This would be done, or this would be investigated regardless of political affiliation.
Agreed.
So my red line is to delete as a Democrat running,
I agree.
okay?
So it would read pertaining to your candidacy for the District 6 nomination.
In fact, your red
Correct.
line didn't take out A.
Yeah,
As
that
a-
is what we were talking about prior to the meeting, is that my line was
Oh,
not long enough.
Okay, well, get in line here.
Yes, my line was not long enough, so,
As a, it should say as a.
correct, okay.
Democrat.
The second red line that I had was for the last sentence, after the comma of 2023 to the comma, I'm sorry, not the last sentence, the second to last sentence, to combine those two, and after the second, or after the comma of 2023, to combine it to say comma, the board, which is directly after the word thereafter. And the reason for that is because, as you so kindly noted at the last meeting, which was your first meeting, and I could not agree with your words more in kind of your opening statement, was I believe that there's nothing else required for us to believe and kind of initiate an investigation. We need nothing more than that article, which is what was the impetus of all of this. So my proposal was, at the meeting on March 2nd, 2023, the board voted that there was a substantial reason to believe that the election law violation had occurred, and that it would be expeditiously, oh my gosh, I'm sorry, make an investigation pursuant to IC 36531.
I have a suggestion.
Absolutely, it's what we're here for.
Okay, the board voted that there was a substantial to believe that one or more election law violations had occurred, because this to me looks as though it locks us into one.
An election law.
Yeah.
Thoughts?
Well, I've not gotten past the prior red line, that the taking out the members of the
Yes.
election board review Mr. Ellis' complaint, which, let me say, I agree with what Nicole has said.
Thank you.
But I want to go back to the
Absolutely.
prior one, which I know from what Molly said, County Attorney Molly Turner King said, one of our duties is due process duties is to give notice. And one of the things she said is that we should probably include with this letter copies of all the things that we're relying on, which would be the Ellis complaint, the IDS article, and information provided by you. And at an earlier meeting that I didn't attend, and I haven't actually seen what information that is.
I'm happy to give that to you.
Well, and we're gonna, when this is over, we're gonna go to the Xerox room and exchange copies, and maybe even come back in and give them to anybody who wants them, in case the press is interested. We would just short-term recess to get the copies all made. But if it's something that has been presented and we've been considering, it should probably be provided. And if it's going to be provided, it should probably be referenced.
So I have no problem with that. The only reason, again, in my effort to be simple and concise,
Yeah.
I think that it is, I hesitate to put words in anyone's mouth, but in consultation with IED, it is my understanding that they said it is not necessary. You say that you have substantial reason to believe, you get to the hearing. And the hearing is therefore your investigation. I don't have any problem with that. We'll need to do it all again anyway, in terms of, we're going to need to print the IDS. We're going to need to reprint the emails from Mr. Ellis. We're going to need to reprint the lease, because as Mr. Henry stated prior to you, we only had one page of it provided by the landlord. So those are all things that we need to do regardless. I don't know that it's necessary to do now. That's my 2 cents. Doesn't mean I'm right.
A piece of it we couldn't do now because we are inviting the landlord to meet with us and bring a copy of the lease with him. We didn't ask him for it to provide to Mr. Bender.
But if we have relied on the one page,
We never said we relied on that.
well, if we've reviewed it, if it's one of the factors that's in our consciousness when we're making this decision. Let me ask, do you have any, I'm sorry, I know you, but it's been a long time since I practiced law.
Jeff Cockrell.
Thank you, Jeff.
I guess my feeling is the end result and the goal of this is to have the person who you are asking to come and having a hearing about to be able to come and give you the information about what the issues are. And I think the more information they have about how we arrived at the conclusion makes that hearing more efficient. It allows you to get to the issues quicker, and it allows you to really hone in on what the details are. And so I think giving him that kind of information, not only is there a due process element to it, there's also a judicial efficiency to it in regards.
Okay,
Thoughts?
thank you.
Yes, thank you.
I want to defer to the IED. They provide guidance, and I think they probably see more of this type of thing than I would or do. So I'm perfectly comfortable. Would there be, Mr. Cockrell, a way to phrase it like including but not limited to, because I agree, there's no point in a one-page lease or a copy of something that we just happen, thanks to the generosity of a tenant.
And to be clear, not to interrupt, but those things are anecdotal at this point. I mean, that's me saying that here's the, you know what I mean, here's the one-page lease. That's me saying that the folks that live there, I mean, I certainly would like to believe that I'm a trustworthy man, but
I believe
you
you're
guys
a
don't,
trustworthy
right? Like, you guys don't know that.
It's not,
I do.
it might be something I think is all nonsense, but if I looked at it when I'm making the decision,
I don't think we did because it was, I only gave it right then and there
Correct.
because it came to me
Let
right then and there.
me say this. My leaning is to put it in, and maybe that's because I did practice law, but I hear both of you saying you're comfortable with that deletion, and I brought up after Nicole made the thing I agreed to, I need to talk about that deletion. I feel that the two of you are comfortable with it. I'm not uncomfortable with it. I don't think it hurts anything. I like it, but we don't have to do that. So I'm perfectly comfortable saying, I'm comfortable with that deletion. You both seem to be comfortable with the deletion. I move we delete it.
Yeah. Here,
Fair.
yeah, and just to tie that a bow
Yeah.
on that, one of the things that has been very important to me, and I never met them or anything, they were very generous to just say, yeah, let me show you who's gonna be living in this house. The people who currently live there have done nothing wrong. They were incredibly generous to just say, hey, I got a copy of my lease in my bedroom drawer or whatever, and you know, I can scan it quickly or whatever, however we got it. And all it showed was that Mr. Bender's name was not on there. We're inviting the landlord to share with us, for our own edification, the entire lease. So if it was somewhere in there and they scratched his name out, or then we would see the whole thing, and we would certainly consider that lease in its entirety if he was kind enough to share it with us. Right now, I feel like the kid was just nice and just gave us a copy of the front page of his
Right.
lease.
So that sounds a lot like a second.
I will second your motion to leave that
All right,
as an omission.
There's a motion and a second on the table. All in favor of that particular deletion, say aye.
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 Just so I make sure I'm following, because I think we've.
Do you have a copy of what we're talking about?
The letter I do.
Yes.
With the deletions that Donovan.
I do not, but were we talking about the language after the March 2nd, 2023?
Yes, so for clarity here, let me just give you the lines.
Okay.
Fifth line from the end of the paragraph, starting at the meeting. comma, immediately following 2023, delete all the way to the comma after thereafter.
I mean, I would almost make a suggestion, you guys can take it or leave it, add which could be found on CAT's TV, and you can watch it for yourself, kind of. You know, go ahead and put CAT's website, the website to the meeting, so we can watch the meeting. Because you're referencing at the board meeting, which can be found here, the board.
I don't know that we need to put I'm happy to add,
I mean,
feel free to review all of our publicly available meetings on this web, or the
Yeah,
CAT's,
yeah.
whatever that might be. Is that something that you guys wish to add?
I would be fine.
I'm not opposed to that in any
I'm
way, shape, or
comfortable. I
form.
think it's a good idea.
Do you have a copy of that one page?
Which page?
The page with the names of the people?
Oh, yes, somebody, can you look through that one?
Yep.
Yes, it should be at the back. So,
Do you mind if I forward that to Jeff, because
Not at all.
still got his email.
it's got my red lines on it, but I don't know that you'll be able to see a copy anyway, if you don't have a piece of
Well.
technology.
Oh, I see, he doesn't have a computer. Well,
So then we've,
I'll work to get what we need after.
okay, and I'm literally.
I just wanted to make sure that when somebody watches the meeting, they realize what was being voted on in that.
Yeah, for sure.
I think it's a great idea.
And I think that, just so you know, Mr. Cockrell, I'll just provide you this physical piece of paper. I'll just take pictures of it or make copies, and you can have it for Ms. Turner King to make these amendments. The second part, or third part, whatever number we're on, was the code. We've already voted on that essentially, so I mean, we don't really need to do that again. The part at the bottom, that second from the bottom paragraph, a copy of the email, again, that's basically reiterating the sentence previously that we just deleted. So I think that we need to just move to get
So
rid of
moved.
that as well. Do we have a second?
Second.
Motion and a second. All in favor, aye?
Aye.
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 Motion passes. So we're deleting that.
The entire paragraph?
Yes, a copy to enclosed. The bottom of that page, the sentence that says you may appear in person and/or, this may be a better question for you to be able to go ahead and review. I don't think that's necessary. It's not you may appear or send your counsel in your stead. I'm not interested in giving Mr. Bender that option. If he wishes to do that, that's fine, but I'm not inviting it. I'm not a lawyer, I'm not a judge. This isn't a courtroom in this setting, it is a courtroom, but not for us. I don't wanna talk to attorneys, which we may have to, but I don't wanna talk to them. I wanna talk to Mr. Bender, and I have a very simple question. We all do, it's one question essentially. And so I was of the opinion that that line should be deleted, because I have no intention of inviting the counsel in lieu of Mr. Bender.
Well, from my perspective,
They may come.
I really like that sentence. I mean,
Tell me
this
why,
is,
would
it's
you?
because this is a notice of us having a meeting. And gee, is this a meeting that anybody gets to talk at? I mean, we might not let anybody talk, but we're gonna let him talk. It's a meeting about him. I feel pretty strongly that we wanna say, you can appear and you have a right to counsel.
That's not what I'm saying. Let me clarify that.
Maybe I'm,
It says and/or through counsel. I'm not saying that we should make any note whatsoever that he's not entitled to counsel, shouldn't bring his counsel, so on and so. We already know he has counsel on this
Right.
matter. I'm saying this sentence very clearly reads, you can appear or you can send your attorney instead of you. That's how I read it.
but that's, I'm comfortable, I think that's his absolute constitutional right. He's not.
Correct.
He's in this is a quasi judicial matter.
This is an
He's-
administrative matter. This is not any way, shape, or form judicial. This
Okay.
is administrative, to be crystal clear. This is still totally administrative.
Okay, we are conducting a hearing, which may result in him being referred to prosecution and him having prosecution. If that's the case, I think he has the right to have a lawyer come down and say, IC 1612-2-2 says that you all have lost jurisdiction because you didn't make the decision within 30. I don't know. You know, he can have a lawyer come down, and I
That's not what I'm saying.
I know, but what I think this sentence says is you have the right to appear in person or by counsel or both. And I feel we need to say that. Now, if there's a better way to say that, fine, but I don't know. You may appear in person and/or through counsel at the time to present evidence and/or argument concerning this matter. I mean, I don't think it could be any shorter or sweeter than that.
I won't belabor the point. My only issue is I don't want to invite, say, you don't have to come, you can just send your attorney. That's how I read it. That doesn't mean that's how he will read it. That's how I'm reading it, and I just don't like that.
That's what I do want to say. I like that.
You would send the attorney to speak for him?
I wouldn't send the attorney, but if he wants to send his attorney down here and not say anything himself, that's his right. But the attorney can come down here and make argument. He can say, you all aren't abiding by the statutes. You all didn't. I don't know what he's going to say. I don't frankly think I don't know what he's going to say. I don't know anything he could say. I don't know, but many a lawyer has said things when I didn't think there was anything they could say. And I feel it's our substantial duty to make clear he has the right to remain silent and he has the right to be represented by counsel. And I think that's what the right to speak or remain silent and the right to be represented by counsel. I feel pretty strongly about leaving that sentence in. And I don't want to invite trouble, except the trouble I'm willing to invite is you got a right to counsel and you got the right to say something or not say something.
What I hear, we are in no way suggesting that his counsel is not welcome to be here. What I think we want is to hear, he has the most direct knowledge. So what I hear is we want that direct knowledge from him. Having said that, if there is something that he's not comfortable, or he or his attorney is not comfortable, I mean, I've watched enough true crime series to know that they can say, I'm going to advise my client not to respond to the question that the board has just asked. Is that fair? Is that right, sir? You can say, I don't want my client to answer that question.
Well, we can say that all we want.
And then what would we do?
Well,
I
it's
I-
interesting.
I guess one thing to keep in mind is that you're going to have, and you have information that you've already looked at in order to get to the point where you're at. And you have said, we think that there's a substantial
believe.
reason to believe that one or more election laws violations have occurred, right? So you've let them know that we've looked at it, we think there's something here. And so, then he has to come in and say, hey, we know you think this, and here's why not, right? That's kind of where we're at, because you've kind of looked at it, and you've looked at information. They should have the ability to look at the same information and then be able to clarify to you why your reasonable suspicion is no longer there, right?
Can I make a 2-sentence suggestion? The election board is requesting your appearance at this hearing. You are welcome to be accompanied by a council member of your choosing. That's not inviting, and then leave everything else off.
Let me make a side comment to that. The reason that I said I wasn't going to belabor the point, but now I am. The reason that I'm so adamant about this is because in my incredible reading that was just so entertaining, we have some, according to this, we have some interesting opportunities here. One of the parts that I have under here is, and I had noted this the last meeting, is that I want a generous but firm deadline for Mr. Bender to say, I'm not showing up, go fly a kite, or I will be there. And I want that because any time leading up until the 18th of May, save for probably May 17th, we have the opportunity to reconvene and then issue a subpoena. Okay. Under election law, when we issue a subpoena to compel a witness to come, we have the opportunity to have the sheriff serve it, which is directly in here. And then if they do not come or respond to that subpoena, let me read you this, which I think is quite interesting. 36529, no, I don't. Refusal of a person to attend or testify, court order / contempt. If a person subpoenaed by a county election board refuses to attend or testify, the board shall report that fact to a circuit or superior court of the county. The court shall order, not an opportunity for said judge, shall order the witness to attend and testify. If the witness fails or refuses to obey the order, the witness shall be held in contempt. I know shall is a big word for attorneys. So I want, that's why I'm stressing that word. Now, a judge, of course, could do whatever he or she wants, but the law is quite clear. So that is why I'm so adamant about saying, look, you're welcome to bring your attorney. I don't want to invite Mr. Bender. I feel like that's a get out of jail free card in terms of you can have your attorney come and you can have your mom or dad come instead of you to talk to the principal. That's exactly what I feel that sentence reads.
Really?
That's how I feel it reads.
Okay.
In lieu of you coming.
Because I'm coming on board with you.
Maybe I'm wrong.
Because in my mind, this was always going to be a conversation.
Absolutely.
Where we're making you welcome to tell us what happened that led up to this. It took a turn when we started getting correspondence from an attorney. I think it was said, you know, who just gets an attorney in response to some very simple questions about residency. So this was always going to be a conversation, and I still am hopeful that it is a conversation. So I'm kind of on board with you that.
Which is why we invited him in
Correct.
lieu of immediately issuing a subpoena.
subpoena.
Because we want it to be a
That's
conversation.
what, that is what you said, Mr. Loffman, when I wanted to issue the subpoena.
Right, and what I'm saying again is, we are saying we think he committed a crime. He has an absolute right to stay silent, to not answer. If we issue a subpoena where we are saying we're investigating whether you committed a crime, I rarely guarantee what a judge will do on anything, but a judge will quash that subpoena. It will take months.
If we say what? Say that again?
If we say a letter like this, which says, we think you may have committed a crime, and we're looking at referring it to the prosecutor,
Yes.
he has no duty to say anything. And if we issue a subpoena, the lawyer has advised you likely to move to quash that subpoena. If he moves to quash that subpoena, months later, hopefully not years, months later, it will be granted. And we will have, instead of, if he doesn't show up, we have everything we need. If he doesn't show up, we number one, we can't make him show up. We might make him show up, but we can't make him testify.
You can make him testify, he just doesn't have to answer. That's what that law says. Because this is not a legal proceeding, this is
My
administrative.
understanding in the criminal law, and this is gonna be, you know, that the judge is going to quash the subpoena, because if it's pointless, it forces the person to go through a process. The judge is very likely to say, you know, if the lawyer says, I'm advising my client to take his Fifth Amendment privilege, I don't think the judge is going to say, well, come on down there and stand up in those people, and when they call you and ask you a question, say, I don't want to answer anything. And it'll be months down the pike. My feeling is there's a lot of comfort in my view if we, on that day,
Did you hear that? Pay attention. This is important.
have our hearing, and at the end of it, if we've got the ADS article, we've got the one page of the lease, which is sufficient, we've got, by all means, all we need is the things he filed with the county clerk.
And that's how you brought me on board to issue
Yes.
the invitation
Yeah.
instead of
And
the
to me,
subpoena.
I don't need anything else unless somebody says something. So to risk putting this off for months and months and months when we can get the ball rolling. The only ball we are going to ever get rolling is to get this to the prosecutor's office, and inviting delay defeats what I think is our interest.
You just led me down, whether intentionally or not, you just held my hand down that path. That makes so much sense. We potentially, the pros and cons of although it might be great to in theory, say, we subpoena you, we're gonna make you testify, you don't have to say anything, but you have to testify, this isn't legal, blah, 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 however that reads. I think what you're saying is, none of that's relevant if it gets pushed down the road, kicked down the road months, years. It is only, and this goes back to what we initially started, our only duty here is to determine whether or not we feel a violation was committed and let the law handle it.
And let
Is that right?
Yeah, absolutely.
Whatever, I don't have a problem with the sentence. Now, that does bring me to the next one. Is there a motion to change it at all from you? Or do you wish to just leave that particular sentence alone at this point?
So we're talking about leaving that first part in, you may appear in person
Yeah.
and/or through
just that
counsel,
sentence.
just that sentence. And the board, and then going it straight into the board request that you provide a copy of the lease that you referred to in the interview with.
Well, no,
me.
we're not even there yet. We're just
We're
talking
not
about this
even there.
sentence. Are you
Okay.
okay with that?
Yes,
And I'm okay with that too. I just do want to note, and I think I've made it clear, I just don't like that, the way I read it. That's all. Irrelevant, but I
You
want to
have
know.
my deepest sympathy.
Thank you. I appreciate that. Second part, which goes to exactly what we're talking about on Mr. Loftman, you unintentionally stated the exact reason I wish to delete almost all of the rest of that paragraph and insert directly after that, for your record there, Mr. Cockrell, the election board also requests that, stop. And my suggestion is to delete everything else in that paragraph and simply add, you provide a copy of the lease for 304 East 16th Street that you referenced in, that could be put in there, in the phone interview with the IDS, which is, after I reread it, he didn't actually state anything to the IDS about a lease. It was stated by the reporter from a phone interview. So he wasn't necessarily stating that as part of the article. I don't know how that works. We could take advice from a journalist on what that is, but it was in the IDS article. The reason that I wish to delete all of the rest of that, and I'm not sure if the insertion of this particular sentence by Ms. Turner King was a direct response to what I said at a previous board meeting, but maybe it was, maybe it wasn't, but I vehemently disagree with the fact that we might not make a decision to prosecute, to refer to prosecute. This is my opinion, not that of the board's. Should Mr. Bender not show up? And should he not agree to speak, or his attorneys? I can tell you right now, that is an immediate motion from me to refer to prosecution, because there's nothing else I can do, and I feel I have enough information. So again, you probably unintentionally just supported why I want to delete that. You may not agree with what I just said, but that's why I wanted to delete that, because I don't see any reason why we need to make all of that fluff there as a statement to Mr. Bender.
So you didn't think that he actually referenced a lease, so I went through.
No. The lease that was referenced in the article was stated ... in a phone interview with Mr. Bender.
No, it says, Bender said in a phone call that he had signed a lease at 304 East 16th Street. He said the Henderson Street apartment was his mailing address, and that he was in the process of moving his things, but did not say when he was moved out. These are attributable to his words on that call.
I said that incorrectly then.
Then they asked him to provide a copy of the lease to verify his residency claims, but he refused to provide it, citing, so to me, he cited privacy concerns. He was asked for any document proving his residency, but no documentation was provided as of the publication. In the phone call, he repeatedly said that he satisfied Indiana Code Title III, but did not state exactly how he satisfied those requirements.
So I apologize for being confusing. Let me reiterate and restate what I was meaning by in the phone interview. I was trying to make the point that those were his words and not that of the reporter.
Okay,
Does that make sense?
we're in agreement.
I was just simply stating that the reference to the lease was not just the reporter writing,
Correct.
this, that, and the other. These were David's words that he was essentially quoted.
Right, so I think we can ask for a copy of the lease because he said,
Oh, of course we can ask. Yeah, absolutely.
but I'm also hopeful that the landlord will respond to our invitation. And-
Agreed.
And I don't have to keep it, but for your review, could I have it back? You know what I mean? If the landlord came and said, for your review, I want you to see the whole lease, but I want to take it back, at least we can say we saw it.
I guess, I'm a little, I think we're getting into the procedures of the hearing, and I'm not sure. To me, if he's offering the evidence, it's evidence, right? He can't,
Mr. Bender or the landlord?
either.
Okay.
Right? If they give the document, it's part of the record, it's part of the record. If he doesn't want to give the document, he can provide testimony. But we're not having evidence presented and then not having it as part of the record later, right? We're not gonna, that is just not a very sound or competent way to move forward.
Well-
But I think that, I think you guys are getting ahead of yourselves, and that you're
Right.
getting into what happens if this happens at the hearing or that happens
Yes.
at the hearing. And what happens at the hearing is gonna happen at the hearing, and that's,
And I'm still, I guess, kind of trying to provide privacy for those tenants. If Mr. Bender has something with Mr. Bender's signature on it, then yes, that is evident. But I still kind of, there are people who signed a lease in good faith or after consulting with their parents or whatever, who have done absolutely nothing wrong, may or may not want you to have.
and I guess from my feeling, if Mr. Bender shows up and he's part of the hearing, he will give testimony under oath. And then that's where that comes out, whether that document's there or not, or anything like that. Again, I think we're moving ahead.
Yeah,
I guess
so-
I would just react to what you said, in that, what I read this to say is that because you're talking about your motion, that it says the election board will not, in no way will the election board make a decision regarding the complaint solely based upon their failure to appear. It's not that.
Yeah, I'm not disagreeing with that,
I just,
I can read that, but it doesn't need to be there in my opinion.
And the IUD supported, or the offered guidance that
Yep.
would be acceptable, that we didn't need to include it? Or did?
Well, that's just, no, they didn't say I didn't even ask about that, that's my
Okay.
opinion.
Sorry, sir.
Yeah, I don't know why I don't think we need to say that. I'm just saying, again, in an effort to be concise, I think after that, we simply add that you provide a copy of the lease, because that's really what we need, and it wasn't asked for in the original draft here. That's why I know that's pertinent information that we want to see. And then, I also don't think that we have any need to say the second paragraph there about has also invited the individuals, because I will state as a matter of fact, this isn't me misinterpreting anything the IED said. We are not a judicial body. This is not a court, and this is not a trial. So we can simply, if we didn't want to ask anyone else for anything or ask them to appear, and only asked Mr. Bender, and he came, there's no one or no thing that he can rebut to or cross-examine. Likewise, even if those folks do show up, whoever that may be, the IED reporter, Mr. Ellis, the landlord, the tenants, we do not procedurally have to allow them to question those other folks. This is not a trial. So we don't have to do that. So that's why I suggested we get rid of that. And in lieu of that, add again, what I had asked for previously, the gentle deadline, generous, gentle deadline, but one that we set. So again, that really has nothing to do, that's more just fluff that I don't think we need, that we can turn this into a one-pager, and I think that it's more than sufficient for what we need. We want David, and we want a copy of the lease that he talked about. That's what we want.
Let me say, and it drove me crazy during COVID. People would say, out of an abundance of caution, we're going to do something totally ridiculous. We're going to tell you, you can't talk on the phone to somebody because it might go through the airwaves. We don't know that. Okay? By the same token, there could be an excess of caution so that you can't get anything done. I think lawyers, when it comes to due process, tend to be very cautious. Nobody wants them coming in and saying, oh, well, wait a minute, you didn't tell us. And all of this fluff is an abundance of caution. It's harmful because it makes it longer than it otherwise would need to be. But if the only harm is the length, I practiced law for 40 years, I'm used to seeing that excess. And it doesn't bother me. On the other hand, it's an excess of caution. It may be an excess. If you guys want to take that out, I'm willing to take it out.
Let's take it out, just, and because I don't remember who referenced it now, getting older by the day. As somebody already said, if you want to know what we've been looking at, all of the meetings are on cats. So what do we want? Him, a copy of the lease he said he had, notification if he's not going to appear, so that we have ample time to issue a subpoena.
Which we
I
may be advised to do that, but I still think we need to be notified if he's gonna appear. I think that's fine to put
we
in
can
there.
ask. I guarantee he has no duty to notify us if he's going to appear.
He does not have any
No.
duty.
And
Correct.
if we can ask, and it's a court,
Yeah.
it's a polite thing to do, but probably, and maybe they will. I wouldn't be surprised if the lawyer,
It's not that, no, not there yet.
Okay.
Just not there yet. So
I wouldn't be surprised if the lawyer does say, we are not going to appear, we are not going to give testimony, we are not, because otherwise the lawyer has to physically come down here to do it, or if he's going to write us letters, he should appear at the hearing. It's not professional to, and, you know, get this behind him, get this, you know.
Then a simple sentence of the hearing will take place whether you appear or not. The hearing is going forward, but we want you to, we'd rather you be here than not,
We
to
would like
protect
to
your
have you
own
here, but
interests.
you don't have any duty. And I think, you know, I am comfortable with that, you know. I would leave it in, but I'm comfortable with the deletion. I'm comfortable with election board requests a copy of the lease for that you referred to in the phone interview with the IDS. And we also request that you notify us of your intent to appear in advance of the hearing.
There you go.
Okay.
Here's what I would say.
And I'm comfortable with all that. I would prefer adding your 2 sentences, but leaving, although they may be.
Leaving all the rest
Leaving all the rest, but
and
I'm.
adding those. Here's what I don't want to keep in there.
Okay.
The last sentence, I am in a major disagreement with. We had a conversation in the last meeting.
I'm willing to take that one out.
Yeah, it was, and I think it's absolutely
The last-
absurd that that's even written in
Okay.
there.
The
We'll
last
take it
sentence
out.
in the paragraph? or-
About being able to provide a written statement in lieu. When I specifically asked if we could do that for the landlord who may live in Timbuktu, and we don't want to drag in here and we've been advised against that, which
I'm with you. I'm with you.
so I do not like that sentence
I'm
whatsoever.
perfectly happy taking that sentence out.
I'm with
So
you.
we can, we'll have to find a way grammatically to add both of those things, but then, so we're really just looking to remove a written statement or any reference to a written, which is the last sentence. I think there was another, if you do not attend. So actually, the last 2 sentences, if you are unable all the way to hearing, is what we would be talking about removing. Is that fair?
Right. We step the rest of it
And then add those other 2 statements.
and add those other 2 statements and take out the last 2 sentences.
Do we have a motion?
I will make the motion to make the edits as described.
Second?
We have a motion, a second.
Does that help you, Mr. Cockrell, or do you need me to stay?
It's on Katz.
Okay.
Yeah.
So I guess at the end of this, I think what you should, the final motion would be, we are going to approve it as amended with a review of, or is one of you the president of the,
I will redraft it as approved and send it back to Molly for
Okay.
consideration for the other 2
Because
members. Is that fair?
I got most of it.
I'm clear. We do, the only thing that is not clear is after the word "that," how I'm going to add the sentence at the top, but I will make a way to,
Right.
So-
Can you say a copy of the lease be provided? Because,
right, it'll be
Okay.
included, and I won't delete anything other than those last 2 sentences that we talked about. So there's a motion and a second. All in favor, say aye.
Aye.
Aye. Motion passes. And then the last thing is simply the whose number was requested. It is my opinion that it should be the clerk's office or the election office if they wish to reach out, but I don't know who.
Mine is it should be council. I don't want them talking.
Our council?
The
Legal
the
department.
county election, county council.
I'm okay with that.
County attorney. I don't want anybody contacting you, any of the 3 of us.
No, the election office, which is
Well.
voter
the-
reg or the
But this
clerk's
says clerk's
office.
office.
so
I
county,
think that any communication from them should go through council,
county legal,
through county
is
legal.
that 2525?
Yes.
So we want to use 812-349-2525, which is the main number in county legal.
Easy.
Yeah, and so election board care of Monroe County Legal
Legal
Department at that number.
Obviously, we would be made aware of that, yes.
Correct.
Okay, easy enough. On to the landlords.
I have one question. And maybe this isn't a real question. You had talked about sending the IDS article and some other information. is that, but we took that language out
I
of here,
think we
so.
took it out.
Yeah, we took
So
that
are we
out.
gonna enclose the IDS article or anything like that, or is this just a letter?
No, it's all on CATS and that's all publicly available at this point, so.
And I'm not sure you guys voted on my suggestion of adding the CATS website
Oh.
at the meeting on March 2nd, 2023, which can be viewed on the CATS.
I will make the motion to put the edit in
Okay.
to reference the meetings that have aired on the CATS television channel.
A second?
Motion and a second, all in favor, aye?
Aye.
Aye.
Aye, motion passes, thank you. Okay, any other questions or comments on that one? Thank you for that, Mr. Cockrell.
I'm gonna say this about this one just before we go on to the next.
Okay,
I think administratively, because I wanna know the answer before we go on to the next one. I think that we're suggesting, you've got this in words, you've got the edits, you've got good notes on this, that you are going to, that we have now approved this letter, you are going to try to get this all in one, circulated to the three of us and Jeff and Molly. If all of us say, yes, that accurately reflects the decision we made, then we'll send it.
yes, we don't, I mean, we can say that individually to Molly, we don't need to say that as a group, obviously.
Correct.
Right,
But-
right. Each of us will advise the Molly, or whoever in the
Yes.
county attorney's office is, we're working with at that point, probably Molly, that we've all approved it, or we say, oh, wait a minute, there's,
Yes,
you
so,
know.
the one thing I will say is, I did ask for, Molly had originally sent these in PDF, and PDF is not easy to edit other than by hand, which is why I did this by hand previous to receiving the Word docs.
Right.
So what I will do is, in my previous life, I'm still a big nerd, but in my previous life, I actually edited papers for pay. So, I will be using, Word to make these edits, so you will be able to see everything, much like it is redlined here. But then I will also submit a clean copy
Yeah.
to Molly, so you guys will both, you'll see both what we changed and
Yeah.
the
What's
final
out,
version, what will be
what's-
sent.
What's old, what's new, and what's out.
Correct, correct.
And you'll do it so we can see the dirty copy and the clean copy, and that's great.
2 copies, you got it.
Right. I think
Well, I
that's,
won't send it to you, Molly will.
Do you
good
have,
point.
I mean, I
You'll
can send it to you individually, but there's no
No,
point.
I
to-
send it to Molly, let
Yeah.
Molly circulate it, let Molly talk with you if she wants
Yes.
to, and then send it to us. Molly will send it to us when she's ready. We don't need we just need to confirm. It's like confirming the minutes.
correct.
We're just,
At that point, I would say we do not need to reconvene. At that point, if Nicole sends something to Molly and says, that's what we said at the board meeting that we approved, you send that after review, that's what we approved, I send that, that's what we approved. I mean, that's not a vote, that's just reiterating what we already approved.
yeah, we've already.
I think it's gathering signatures, right? Because we're gonna have the final draft.
Yeah, we could come in
You'll each
here.
get a copy, and you'll say, I'll sign it or I won't.
There you go. I like that, even better.
Perfect.
Do we have a date that these are going out?
I mean, I'll have this done by Monday.
Yeah.
I'll have this done this evening, and I'll send it back, but it's irrelevant because we're not, into business is gonna be in a couple hours, so.
The only reason that I'm asking, because we're giving him an opportunity to decline to come. And we would rather know sooner than later that he's not coming. Is that,
Well, I think what we had decided was instead of X, just, please let us know, of your intent to appear prior to the date of the hearing. I think that, I know Mr. Loftman is on the board at this point for this matter, but I think what I was getting at about him leading me down the road is a subpoena may be just elongating a process.
and I'm with you.
Does that make sense?
We're there,
I
but kind
agree
of
with you.
kind of like preparing for a party. Let's put a happy tone on this. Kind of like preparing for a party. You would want to know how many guests you could expect so that you know what the amount of groceries you have to buy,
Fine.
the amount of bottles of wine you'd have to buy.
How about 2 weeks, to go back and edit that, instead of prior, how about 2 weeks prior to the meeting? So 8th, whatever the date is, what's 8,
Put in the
14?
date. Put in the
Okay.
date. There's
2
no-
weeks prior.
It's just a request. He doesn't have to honor it.
I'm not gonna do math on camera, so
I will.
2 weeks
2
prior.
weeks prior.
You're not doing math, you've got a calendar.
That's
for
right.
it.
2 weeks
That's
prior to
cheating.
May 18th is actually happens serendipitously to be the date of our election board meeting, which is May 4th.
So then let's even just put a
May 3rd.
time.
Let's put May 3rd, so when.
There you go.
When the election board meets, if he's notified of
Easy.
anything,
Fine.
then.
And we can announce.
Do we need to
he has
vote on that,
indicated-
or we kinda already, that's fine. We can just circulate as is, right?
Yeah, because if we'll sign the letter or not.
Fine.
Now, it seems to me, Jeff, how much notice do we have to give him? Is there we need to notify him, I mean, assume. So if we give him a month's notice, that's a lot.
Yeah.
You know, that's
Right.
more than enough.
Yes,
May, our meeting is May.
May 4th.
No, that's the notify.
Oh, I'm sorry. May
our
4th
meeting-
is the May election board
No,
meeting.
but our meeting on this is May.
18th.
18th.
May
18th.
18th. So
Correct.
as long as we get it out by April 18th,
Well-
we're giving a month's notice. And we're going to get it out long before then.
I was gonna say, unless I make a typo, we've agreed to everything.
Correct.
So
But
it'll
no-
be out longer.
Well,
Way
but we
longer.
need,
So I would-
are we going to physically sign it?
Yes.
Yeah, so we
And
each
we
need
can
to.
go one at a time and do that. I would say with a goal to have it out by May 7th, which is, I'm sorry, April 7th, which is 1 week from today. That gives time to make the edits, time for each of us to go individually to get signatures, time to get it in envelopes. And did we talk about the service, Bloomington Police?
I think certified
Certified
mail
mail.
return
Certified
receipt is,
What do
Yeah.
you think?
I think certified mail where, they've got to sign the
So was
green card.
the police only for, if we had issued subpoenas?
Subpoenas,
Yes.
right.
They would have served them
Well,
for us?
I think if they all come back and say, not deliverable to this name, to this address, then I
Yeah.
think the legal department would start looking at contacting the sheriff to see if they can serve this person or not. I think it's important to get service on them before the hearing and have that, but I think this certified mail.
but he has appeared by counsel. And the first thing we decided was to send it at the,
All three.
to all three. And if we send a certified return receipt letter to the lawyer, they won't.
Yeah, I don't anticipate getting there, right? I don't anticipate getting there, but if we get there,
Right.
we'll
I won't be surprised if the others are not signed, but the lawyer, I'm glad he has a lawyer. I'm sorry, I'm glad he has a lawyer.
No one ever took away his
No,
right
no,
to-
no, but to me, it makes some things easier. So I think we've got a procedure. I'm here for the Board of Zoning Appeals on Wednesday at 5:30.
Okay.
And it would just be handy for me if I could sign, I will have seen it before then, and I'll
Yeah.
be in here next week, so, Dave Schilling
Yeah, well-
is the lawyer who helps us, so if that would be a convenience for me if I didn't have to make an extra trip in here.
Well, I could have it out this afternoon, and I've stated before, I don't think that that's any sort of violation of ODL, but I'm not gonna do anything that you guys don't wish me to do. So, I will certainly edit it, and I will send it to Molly for her to circulate to both
Right.
of you. Okay, any other questions on that one before we move on?
No.
Okay,
Thanks, I'm glad we
absolutely.
got that all straightened out before. we
So
get
this
there.
one should be easy, because a lot of it is the same exact language, or the beginning of it. It's already significantly shorter, which makes sense.
Give me just one
No
second
problem.
to get that up here. Okay, I got it up.
So this one, the first thing is the address.
Yeah.
I suspect this would be a little bit more difficult. I'm happy to do the research on finding It's my gut feeling that that particular home is in the, as a business owner myself, I know that addresses and places of business and rentals and all that sometimes are wrapped up in a web for very, very good reasons. There's nothing nefarious there. It's simply taking advantage of various different tax codes. So I don't know that finding the actual address of the landlord is going to be very easy. What I would say is that finding the phone number is very easy, which is what I did a few weeks ago when I called from the sign in the front yard. And I believe I got a voice message, but anyway, I'm happy to take that on if you guys feel that that is acceptable, or if you want me to.
I am perfectly comfortable.
And
Well-
I'll try to find that.
Do we have anything? Do we know the name of the company?
I don't remember it. It's a blue and red and white sign that was out front. And that might not even be there anymore, but I'll certainly try to find it.
Well, and I think the other thing we could look at, if yours fails, is we could always look at tax records. Where's the tax bill go?
Okay.
Or an address that way too. or-
We can go to
Elevate, but
Elevate and get that in a minute.
that's what I'm meaning about. When you have rentals, very rarely are they in your name. They're in a business name, and that business name may be registered at some apartment in Zimbabwe, right? Like, you just don't know.
As much the property manager as the owner, maybe.
Yeah,
what you're-
so I
That's a
just don't
possibility
know.
here.
Correct, it's a possibility. I don't know the answer. All I'm saying is I'm happy to do the legwork there if you guys, and if I can't come up with anything, then I'm happy to turn that over to someone that may have more power than I, but I don't see any reason why I couldn't get that address. But I'll just drive by the residence again and pray that the sign's still out, and I'll call the phone number on the sign.
This may be silly, I don't know. Again, I probably watch too much television. Those sites like Spokio and things like that, Verify, can we use that?
I don't think any of that's reliable, to be honest with you, but
Okay,
that's just me.
I just see it on television.
I don't think it will be difficult. I'm just saying if I relied on, if the sign is not up and I have to rely on the address and using GIS, it will not, I don't suspect it will be easy. So that's all. So I'm happy to do that. I will do my best to find who that is, even if it's the business, whatever that might be. And we can go from there. The next item then, oh, I'm sorry, are you okay with that as well?
Why, it's ZJJ LLC.
Correct.
What?
And ZJ LLC that I've never seen is probably, that's not what's on the sign, I guarantee you that. So that's my point. Is it, and there's nothing, to be crystal clear, there is nothing nefarious about doing that. Landlords are
No, but,
perfectly legal to do things like that.
But we could get the registered agent.
okay, here's what I'm gonna suggest,
Shouldn't be hard.
is that they work, that Donovan works with county attorney, and the county attorney will determine the appropriate address to send.
Perfect.
We don't need to approve the address, we need to
No.
approve the substance of the
Yeah.
letter, is how I look at it.
I'm happy to look at it. No.
That's not what you're looking for?
No, it's, oh, there,
Look at you.
well, it may be, there you go, that may be, we may be able to find that business address. So, okay, it may be easier than I thought. Okay, so moving on to the substance. Is this mine?
Yes.
Okay. Again, going back to the same language, if you get to the third line after the word candidacy, as a Democrat running, let's kind of take this as a whole if we're okay. We approved that as a deletion. And then in the last couple sentence, that combination of after 23 to the board. That is the exact same thing that we had talked
Did
about
in the other one?
previously.
Yes.
And we insert the website language as well there.
And insert the website language if they wish, yes. Website language. I'm not gonna give specific links, but I'll just put, cats.com,
Yeah.
search for Bloomington or whatever.
Yeah,
Shout
I
out
would
is
just
it
pull up the
catstv.net?
general government, it's like www, yeah, I'm with you.
Okay. The other thing that I had noted is in the previous letter, and I think this is just semantics, but a hearing to investigate this complaint, to copy or to mirror the other one, I put delete to investigate and add on.
Fine.
Any issue there, that, again, just to mirror.
I've reviewed the changes you've suggested and the little additions we made here, and I move we accept them.
I like that better.
I'll second.
Motion and a second on the extent of the letter here. All in favor, say aye.
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 Any opposed? Hearing none, motion passes. That is everything I have. Questions, comments, or concerns, I guess, from the board members before we depart and adjourn for what is probably now recess for what is now officially the longest election board meeting in the history of election boards.
No, it's not, I promise.
I don't doubt if it is at this point.
So this is adjourned or recessed?
Recess.
Well, I'm asking for a motion to recess
But
because.
are we recessing to a date?
Well,
Or are we-
unless something happens, we meet next Thursday for the regularly scheduled election board meeting.
But will that be this meeting, or will that be a new meeting?
So that's a whole different, so I believe that the next meeting that is scheduled, we should probably adjourn this actually, Nicole, now that I think about it.
Because that's been noticed, right? The next meeting's been noticed, right?
Yes.
So
Yes,
you-
but
so you-
Mr. Henry will be there because it is not
I
on
think
this
you
matter.
adjourn this one.
Right.
And because
And-
it's been noticed, there's,
If anything comes up between now and then, or between the provisional and there's.
We'd have to notice it anyway.
no.
What I'm saying is, if something comes up and you want me there, I will certainly try to get there, but that's not scheduled to deal with any of this stuff. I suspect we can adjourn, and then we're starting a new meeting for the hearing on the 15th of May, 18th of May, and I don't think we need to.
Okay then. So do I have a motion to conclude the longest election board meeting in the history of election boards?
I think I have been to longer.
I have two.
So
I will
Not
make
this
a
particular
motion.
meeting, I mean all of the recesses combined.
you're showing your naivete.
Perhaps. Do I have a motion to
I
adjourn?
will make a motion to adjourn this meeting.
I will second.
All right, motion and a second, all in favor?
Aye.
Say aye.
Aye.
Motion passes, this meeting is adjourned. Thank you. Thank you for your help.